We will now resume with an opening statement by Ms. Heaven.
Good afternoon, sir.
Good afternoon.
This is the opening statement on behalf of all the cooperating non-police, non-state core participants who have expressed a view for Tranche 2, Phase 1. It supplements the statements that have been made directly on behalf of non-state individuals and groups by their instructed lawyers. So in the Tranche 1 interim report, you found that the tactic of long-term infiltration of political or single-issue groups by the SDS between 1969 to 1982 was not justified because, subject to a very few exceptions, you found that the means employed by the SDS did not justify the ends. You also found that had the right questions been addressed at the highest levels within the Metropolitan Police Service and the Home Office, and had the means employed by the SDS been publicly known about, then the SDS would have been, in your words, sir, brought to a rapid end. The non-police state core participants welcome these findings. The inquiry ought now to proceed on the basis that what follows in Tranche 2 and beyond is unjustified and unjustifiable. SDS operations in Tranche 2 should never have happened. So you have before you so far in Tranche 2 many witness statements submitted by the non-state core participants, all of whom have been deeply affected by SDS undercover policing. These statements set out a litany of shocking intrusion and abuses by the state of the fundamental human rights of the public, including the right to privacy. It is therefore important that the inquiry recognises that had the SDS been disbanded in Tranche 1, the consequent trauma suffered by many of the non-police state core participants would simply not have occurred. As has been explained by B in the witness statement submitted to the inquiry, quote, "Those means have been very damaging to many lives. Those women they had sexual relationships, those they befriended and betrayed, those whose valiant campaigns were undermined, for example, the families of people campaigning for truth and justice after their relatives were killed by police or racists, and also the mental health of the police officers used as spies and their families who were also betrayed." Now, so on Monday, you heard that the Metropolitan Police Service now accepts and acknowledges that there were, quote, serious wrongdoings by some SDS undercover officers and the mismanagement by SDS and Metropolitan Police Service special branch managers during the Tranche 2 period. And, quote, "There was a general failure by the SDS managers and senior managers in the Metropolitan Police Special Branch to lead the SDS properly and effectively." Specifically, the Metropolitan Police Service now acknowledge, and sir, you'll appreciate this is just a short summary of the salient admissions, that during Tranche 2, there were 9 deceitful sexual relationships, there was unnecessary reporting on political and social justice campaigns, community organisations, as well as groups that were campaigning for police accountability. There was racist, sexist and homophobic expressions and descriptions used in reporting that were derogatory, arrogant and rude, with some reporting not meeting the standards of the Home Office guidelines on the work of the Special Branch, which, as we know, was published in 1984. There's also an acceptance that the Metropolitan Police Service engaged in discriminatory policing in respect of the targeting of anti-racist campaigns that were seeking justice for members of Black and Asian communities in London and attempting to hold Metropolitan Police Service accountable for the way it policed those communities. This was described on Monday by the Metropolitan Police Service as, quote, "an example of unacceptable political policing by the Metropolitan Police Special Branch." So, as you know, the non-police state core participants suggest that the evidence of political policing by the SDS, as overseen by the Metropolitan Police Service, goes well beyond their targeting of anti-racist campaigns and is reflected in all the biased and one-sided targeting and reporting of those perceived by the police to be on the political left wing. Whilst the admissions that have been made by the Metropolitan Police Service are important admissions, and of course they are welcomed, they are also, quite frankly, too little and too late. The non-police state core participants wish to place on record their deep disappointment that it has taken the Metropolitan Police Service until now to make what are qualified admissions in respect of this shameful period in British policing. The SDS was exposed as long ago as 2011. It should not have taken 13 years for the Metropolitan Police Service to say what it did on Monday of this week. The non-police state corps participants note that in their opening statement, the Metropolitan Police Service not only call into question some of your findings, sir, in the Tranche 1 interim report, but they also assert that the inquiry should not be judging the actions of the SDS by so-called modern-day professional, legal and ethical standards. The non-police state corps participants will respond to the points raised by the Metropolitan Police Service on Monday in their Tranche 2 Phase 2 opening in September. But we simply note at this stage that so you've already considered and rejected the arguments that are being made by the Metropolitan Police Service. In the Tranche 1 interim report, so you highlighted some of the key evidence demonstrating that there were concerns at the time that the type of policing being engaged in by the SDS could not be legally justified, and indeed would result in public embarrassment to the Commissioner were it to be exposed. Overall, the non-police state corps participants consider that it's a gross mischaracterisation by the Metropolitan Police Service to suggest that the only real problem with the SDS was that, quote, its good work was overshadowed by the indefensible misconduct of some officers and the mismanagement which allowed that misconduct to flourish. The truth is that the Metropolitan Police Commissioners of the day not only knew about and sanctioned the SDS, but they were so proud of its work that they positively considered it to be, quote, the jewel in the special branch crown. The non-police state corps participants call upon the Metropolitan Police Service to admit and accept that the SDS was a unit that engaged in widespread political policing and that it developed abhorrent and unlawful tradecraft and practices under the direction not just of SDS and special branch managers, but with the full knowledge and connivance of the senior hierarchy of the Metropolitan Police Service, including the police commissioners of the day, namely the late Sir Kenneth Newman and the late Lord Peter Imbert. So I now want to make some comments on the evidence, and for your benefit, I know I've been jumping around a bit, but we're now going to paragraph 28 of the written document you have, and that will be page 13. Now, the non-police state corps participants note that at this early stage, they've only seen part of the evidence for Tranche 2, but it's clear from the limited and shocking information that's already in the public domain in press reporting, publications and previous investigation reports that between 1983 to 1992, the means by which the SDS conducted its activities in Tranche 2 could not possibly justify the ends. In Tranche 2, you'll be considering yet further evidence documenting widespread and systematic abuses of the fundamental human rights of members of the public by the SDS undercover officers, with the support and encouragement of SDS managers, senior NPS police officers, and on occasion, the security service and indeed the Home Office. In Tranche 2, undercover officers continued invading people's lives, abusing women, and engaging in sexual and close personal relationships when undercover, and even after the conclusion of their operational deployment, whilst still using their cover identities. Undercover officers fathered children with activists before disappearing, stealing the identities of deceased children and compiling information on children and teenagers. There is further unlawful trespassing into the private homes of members of the public, violations of the intimacy of private family lives, and the personal and private dealings of members of the public, including partners and children. There is a continuation of widespread mass surveillance and data collection, not just for the security services, but also for the Metropolitan Police Special Branch Registry. Now, in relation to record keeping, in Tranche 2, there's no evidence of any attempt by undercover officers to comply with the 1984 Home Office guidelines on the work of a special branch. The non-police state corps participants are yet to understand if undercover officers and managers understood and reflected on the relevance to the SDS of the Data Protection Act, which came into force in 1984. There is evidence of racist language being used by undercover officers, and an undercover officer alleges being the subject of racism whilst in the SDS. Undercover officers continue to adopt significant positions of responsibility and influence. They directed groups, sowed discord, and acted as agents provocateurs. There is more abhorrent and misogynistic reporting, with undercover officers committing criminal offences and attending court in their cover identities, brazenly interfering with the justice system and misleading the court, resulting in unfair trials and unsafe convictions. STS managers and undercovers in Tranche 2 continue to show consistent disregard for the integrity of the criminal court process, such that it evolved into an established tradecraft. So you'll also see evidence that the STS was clearly being used for a range of unlawful and unjustifiable tasks, plainly going beyond the remit of Special Branch, with significant influence and encouragement from the security service. This includes defensive policing of the so-called, quote, enemy, to direct targeting of police accountability groups and those described as irritants to the establishment. It also includes using the STS to avoid, quote, embarrassment to the state, and widespread reporting on and targeting of family justice and defence campaigns, lawyers and politicians. There is breaching of legal professional privilege and the emergence of a tradecraft of directly penetrating and closely monitoring and reporting on community organisations, for example, the Roach Family Support Committee and the Gross Family Support Campaign, to name but two. This targeting foreshadows the evidence that is to come in relation to, for example, STS targeting of community-based pressure groups, community centres, and the family of Stephen Lawrence, Dwayne Brooks OBE, and Michael Mansfield Casey. Now, so as you know, STS managers will not feature in Tranche 2, Phase 1, but I just want to make a few comments in relation to them in terms of what the disclosure shows and some general points on guidance. It has not been possible to review the evidence of the key STS managers as it was disclosed just a few days ago, but it's already clear that in Tranche 2 it will become increasingly impossible for the STS managers to distance themselves from what the undercovers were doing under their command, and to maintain that they did not know what was happening or that they did not appreciate the inherent risk of abuse and undercover criminal conduct from the nature of the STS operations. In respect of Category H and the women deceived into sexual relationships by undercover officers, the non-police state court participants note that the Metropolitan Police Service accepted in their opening on Monday that, quote, in their written evidence for Tranche 2, Phase 2, the STS managers will each say that during their tenure, they were unaware of the full extent of the conduct detailed above. The NPS wishes to be clear that it does not accept the level of general ignorance professed by STS managers in their statements. Some of them did know or did suspect that sexual relationships were occurring. This admission is long overdue, and you heard yesterday that it is welcomed by the Category H women, along with the important acceptance by the Metropolitan Police Service of the role played by a wider culture of sexism and misogyny in the police. So just to highlight some of the evidence in Tranche 2, Phase 1 on this point, HN 99 Detective Chief Inspector Nigel David Short warned HN 67 Alan Bond about being tempted by, quote, flesh-pot females. We also now know that around November 1985, HN 19 Malcolm Shearing gave a presentation to members of the security services on the STS and tradecraft. HN 115 Detective Chief Inspector Waite gave what was termed, quote, a light-hearted introduction, which included making, quote, a comment to the effect that one of our animal people had been involved in a pregnancy scare, but the fact of the child being mixed race ruled out the officer entirely. So you may consider that this comment speaks for itself. We can also see that HN 78 Trevor Morris vaguely recalled that when he made STS management aware that he'd denied the advances of an influential SWP woman during his deployment, that, quote, someone suggested that a relationship with a woman other than the influential SWP woman might create a distraction and calm the situation down. However, there is also other evidence to suggest that relationships when undercover were known about at the highest levels in the Metropolitan Police Service. As you've already heard, HN 85 Roger Pierce targeted Friends of Freedom Press in Tranche 2 and then went on to become Commander of Special Branch and Director of Intelligence for the Metropolitan Police Service. HN 85 is also a novelist, and on the 7th of June 2012, he published a novel entitled Agent of the State, which features an undercover officer protagonist who fathers a child with an activist who is deceived into having sex whilst undercover. The same protagonist also appears again in 2013 in Pierce's novel The Extremist. This second novel also features a female undercover officer deceiving an activist into having a sexual relationship when undercover. Now, in terms of context, the public reporting of EN12 Mark Kennedy's long-term relationships when undercover occurred in January 2011, and that HN10 Bob Lambert had had a long-term relationship when undercover was reported in the press in October 2011. However, the first reporting of Bob Lambert having a child with an activist was in The Guardian in January 2012. The timing, we say, is significant. The non-police state court participants believe that Pierce came up with his protagonist's backstory and wrote his first book well before Kennedy and Lambert were publicly exposed, and based his plot lines on his personal knowledge of the unit in which he served and then commanded. But not only that, the fact that Pierce thought in 2012 and then in 2013 that it was appropriate to write these books is disgraceful. It perfectly illustrates the sense of enduring impunity that ran through the SDS. It shows the extent to which senior Metropolitan Police Service managers at the highest levels are unapologetic, and even as late as 2013 still considered that the SDS was above the law, unaccountable, and had done nothing wrong. The non-police state court participants want to know whether when Pierce published his books and sought to make money trading on the abuses committed by his fellow undercover officers and those under his command, he gave any thought to the effect the books might have on those abused women and the children of undercover officers that he knew existed. The inquiry should be extremely sceptical about any suggestion from Pierce that he did not know about these matters at the time, but was simply drawing inspiration from the revelations that were exposed in the media. After all, Pierce boasts on Amazon that, quote, in his novels, the author draws upon his knowledge and first-hand experience of a career in national security at every level. When SDS managers for Tranche 2 give their evidence later in the inquiry, it will also be impossible for them to maintain the assertion that is made in every annual report, that welfare and supervision were of paramount importance. In Tranche 2, there is more evidence indicating red flag behaviour, including undercover officers returning to their target groups and raising very serious allegations about the lawfulness of SDS operations. Undercover officers identifying with their target group, directing and inciting groups, undercover officers being placed at risk, suffering mental health breakdowns, developing alcohol dependency, and going absent without leave. So you will also be hearing evidence about what is termed the Stephen Scutt affair in relation to the alleged misconduct of HN95 Stephen Scutt and how it was dealt with and divided undercover officers and SDS managers. In terms of the understanding of the boundaries in relation to privacy, there is now documentary evidence to suggest that the security service considered that SDS reporting on financial data was not justified and indeed ordered that steps were taken to destroy some of this reporting. The documents that were ordered to be destroyed related to HN88's reporting of the financial position and published accounts of CND. So if the security services, who were interested in every little detail, could see that the SDS had gone too far in its reporting, it does beg the obvious question as to whether SDS managers also appreciated the same. The non-police state court participants asked the inquiry to challenge undercover officers and managers about obviously inappropriate reporting that quite probably breached the Data Protection Act 1984. So that some SDS reporting was in part destroyed and not distributed by the security services is a matter that you will no doubt have in mind when you reflect upon the suggestion by the Metropolitan Police Service that was made on Monday that, quote, the concept of personal privacy was not as developed as it is today. So on this latter point, I would ask that you read the Council of Europe Convention for the Protection of Individuals with regard to automatic processing of personal data 108, which was implemented in domestic UK law through the Data Protection Act 1984 and which the UK ratified in 1985. So for your note, it's footnote 38 of our written opening. Now, in terms of guidance, in Tranche 2, Phase 1, there's a reference to a number of new purported guidance documents that have not been seen before, such as Code of Conduct for Undercover Officers, the Code of Conduct for Special Branch Officers, the Selection, Safety and Welfare for Undercover Police Officers, the Code of Conduct for SDS Officers deployed overseas. There is also a document entitled SDS Policy Guidelines regarding participation in crime, which is undated. With the coming into force of the Data Protection Act 1984, there was apparently a recognition of the need to subject Metropolitan Police Service undercover policing by SO10 to regulation. The purpose of SO10 was defined as covert policing and evidence gathering. Curiously, though, it was thought that the rules for SO10 did not and could not apply to the SDS. So this was the era when Sir Kenneth Newman was Commissioner of the Metropolitan Police Service, so that's 82 to 87. And during this time, he published his book and guide to the police entitled Principles of Policing. This book was given to all police officers, and it contained an extensive explanation of how modern day legal, moral, and ethical principles apply to the police. For example, it placed great emphasis on policing adhering to the rule of law and respecting the fundamental rights of individuals, of maintaining police standards and ensuring the regulation of police conduct. Now, of note, we can see in the T2 disclosure that according to HN 122 Neil Richardson, on return from his deployment, SDS officer HN 19 Malcolm Shearing hung a framed version of Commissioner Newman's Principles of Policing above his desk. HN 122 states this was intended as a practical joke. That the SDS undercover officers saw upholding the rule of law and fundamental rights as simply a joke is no surprise. The non-police state corps participants await an explanation from the Metropolitan Police Service and the witnesses in Tranche 2 as to how they ensured that Commissioner Newman's principles were taken seriously and actually applied in the SDS. What is now clear from Tranche 2 Phase 1 disclosure is that officials within the Home Office were on notice of the desire of some senior officers within the Metropolitan Police Service, such as HN 3962 Assistant Commissioner Crime John Wilson, to use the police in illegitimate ways to spy on groups critical of the police, quote, in order that they, the NPS, can adequately respond to criticism. It is also now abundantly clear that at the start of T2, Tranche 2, so that's 1984 to 1986, the Home Office did have some knowledge that the SDS was, quote, directly penetrating or closely monitoring and reporting on defence and family justice campaigns and groups, simply because they were critical of the police. The Home Office knew this was controversial, and senior civil servants such as Sir Gerald Hayden Phillips were concerned. In Tranche 1, questions remained unanswered as to exactly what was known within the Home Office, Cabinet Office, and by the Prime Ministers of the day on the minutiae of the tradecraft of SDS undercover officers. It was unfortunate that senior civil servants and senior Metropolitan Police Service police officers who were able to give evidence were not called in Tranche 1. This was an opportunity that was lost by the inquiry, and this opportunity should not be lost in Tranche 2. Tranche 2 is a pivotal period for the Home Office in this inquiry, given the significant events that occurred. In January 1983, the Metropolitan Police Service published its report on political extremism and the campaign for police accountability within the Metropolitan Police District, that we've been calling colloquially the Police Accountability Report, which caused the Home Office real concern. In December 1984, the Home Office guidelines on the work of a special branch were published with a secret and problematic cover letter. In April 1985, the Home Affairs Select Committee inquiry into special branches published its report following the hearing of evidence. The Home Office involvement in these significant events and the aftermath must be established. The Metropolitan Police Service was accountable to the Home Secretary. The non-police state corps participants therefore consider that the inquiry ought to request a corporate witness statement or a position statement from the Home Office, requiring them to give evidence as to their exact state of knowledge in respect of the SDS in Tranche 2 and beyond. In particular, the Home Office should be asked to address the issues of concern that have been raised by counsel for the inquiry and the non-state corps participants in relation to the Police Accountability Report, the 1984 guidelines, and the giving of evidence to the Home Affairs Select Committee. The non-police state corps participants support the suggestion made yesterday by Mr. Scobie KC on behalf of CND and Lindsay Germain, that new evidence should be obtained from Sir Michael Partridge KBC to sidestep the concerns in relation to parliamentary privilege that were raised in respect of the Tranche 1 closing submissions. I now want to turn, please, to justification. So this is paragraph 38, page 20 of the written opening that you have before you. In the Tranche 1 closing statement of February 2023, the Commissioner for the Metropolitan Police Service accepted that by modern standards, the SDS deployments in Tranche 1 were unjustifiable because of the way they were structured, quote, not least because there was a failure to consider intrusion, necessity and proportionality. The non-police state corps participants welcome the Metropolitan Police Service admission in Tranche 2 that, quote, in many cases, the value of the intelligence produced during long-term, open-ended deployments by SDS officers did not justify the duration and depth of their intrusion into the private lives of those with whom they had contact. The Metropolitan Police Service also state at paragraph 76 of their written Tranche 2 Phase 1 opening that, quote, the fact an undercover officer deployment does not ultimately produce intelligence of operational value or does not do so consistently does not automatically mean that it was not adequately justified and properly motivated at the outset. So the non-police state corps participants do not disagree with this proposition on justification. This is really an issue that arises for the managers, but the point for you, sir, is that in considering justification for a deployment, you must consider the assessment of justification that was carried out by managers at the outset and prior to a particular deployment commencing to check whether there was proper and rigorous consideration of the necessity and proportionality of said deployment. On this point, the inquiry is reminded that in the Investigatory Powers Tribunal judgment, Kate Wilson versus Commissioner of the Metropolis and National Police Chiefs Council 2021, the court considered the lawfulness of undercover targeting by reference to the nature of the authorisations, safeguards and scrutiny and oversight of the undercover deployment. These matters will be dealt with further in Tranche 2, Phase 2. And I want to consider justification through the lens of the annual reports. The inquiry must investigate whether, following the Home Affairs Select Committee report and the publication of the 1984 guidelines, SDS managers, the Metropolitan Police Special Branch hierarchy, and indeed the Home Office robustly and honestly reflected on the work of the SDS in how they dealt with and discussed justification. The SDS annual reports and the Home Office authorisation letters are important in this regard. And so we urge you to give short shrift to the suggestion made on Monday by Mr. Skelton KC on behalf of the Metropolitan Police Service that too much weight is being placed on the SDS annual reports and, quote, the reports were not about justifying the unit's existence, but were simply a stock take. So in Tranche 2, the SDS annual reports portray a unit desperately seeking to justify its relevance, where public disorder was broadly in decline, where guidance to special branches was tightening, with accountability firmly resting with the chief officer of the force through the head of special branch, and where the remit and interests of the security service were changing. The inquiry should scrutinise the priorities of the Metropolitan Police Service and Special Branch through their annual reports to better understand the reason for the survival of the SDS, which, as we know, should have been disbanded. In Tranche 2, given the decline in public order, the SDS annual reports show the unit clearly shifting its focus to various ill or non-defined groups referred to interchangeably as, quote, militant animal rights groups, wide range of extremist street activity, extremist groups, militant left-wing extremists, terrorism and animal rights extremism, and single-issue groups, carrying out equally ill-defined street activity. There is, in fact, no definition of militant or extremist in the 1984 and updated 1994 Home Office guidelines on the work of a special branch. The inquiry must consider whether this is intentional and the extent to which the lack of a definition for these nebulous terms allows the Metropolitan Police Special Branch and the SDS to justify spying without reference to specific policing powers. The inquiry must also consider whether changes in Tranche 2 to the focus of the security service are relevant to the strategic shift in the SDS, In 1991, the SDS began to place significant emphasis on, quote, identifying suspects in breach of the law, foreshadowing the increasing focus on the prevention of crime that will emerge in Tranche 3. The inquiry must probe whether the alleged change in the focus of the security service placed a greater burden on C Squad and the SDS to justify their activities, and whether this contributed to a pressure to produce more intelligence. This is an issue that must be put to SDS managers who had oversight in this era, but also to the undercovers who should be asked whether this had any impact on the requirements being communicated to them. The inquiry is also asked to disclose all the Metropolitan Police Service and Special Branch annual reports for Tranche 2 so that we can better understand the changing demands within Special Branch. And on this point, it's noted that the DL lawyer core participant grouping in their opening refer to a number of annual reports that we have not seen. At the start of Tranche 2, the SDS managers appear to be struggling to justify the unit's existence to the Home Office. As is seen in Tranche 1, there is more evidence of SDS managers overstating the utility of the SDS. The justification of resource saving continues in Tranche 2, with an occasional nod to the Metropolitan Police Service Commissioner's policy of reducing the number of uniformed police officers at public order events. The non-police state corps participants in Category H addressed the legality of the resource justification extensively in opening and closing submissions for Tranche 1. And so you found that the SDS reporting assisted senior officers to avoid the deployment of large number of police officers when not required, but that, quote, its contribution should not be overstated, and, quote, a remarkable quantity of reports concerned groups whose activities had no bearing on the threat of public disorder. The non-police state corps participants agree with the conclusion in the interim report that, quote, the principal explanation for the reporting and retention of this information cannot be that it provided material assistance to those responsible for maintaining public order in London. It has to be sought elsewhere. In terms of public order, the 1983 SDS annual report pointed to increasing volume of demands on the SDS, but this amounted to only a modest increase in the number of demonstrations that required more than 100 uniformed officers, from 150 in the preceding year to 172. The request for funding was therefore grounded on the premise that there was an indication that less law-abiding elements within the animal liberation and anti-nuclear groups would increase activities which threatened public order. Despite an acknowledgement that intelligence was being provided on groups whose main actions included peaceful demonstrations. The 1984 SDS annual report requested funding from the Home Office in part on the grounds that there had been, quote, no respite in political demonstrations and direct action by political extremists, despite the annual report itself concluding that the SDS was operating in, quote, the relatively quiet or public order scene, and that, quote, extremist groups have had a relatively quiet year from a public order point of view. Rather than draw rational conclusions from the lack of threats from the groups being targeted, the 1984 SDS annual report sought to outline that the quiet year was a cause for concern on account of the suggestion that the groups had been, quote, productively reorganising and preparing for an opportunity which they can exploit. The annual report concluded, it is not possible to forecast what this will be, and therefore there is always a need for vigilance. Further descriptions of a quiet year are found in the 1985 SDS annual report. This annual report defensively argued that the movement away from large-scale peaceful demonstrations to direct action did not lessen the need for SDS intelligence. This theme continued into the 1986 SDS annual report, with a shift in focus from large public demonstrations to, quote, various ad hoc single-issue groups. The SDS had no more to say about these ad hoc single-issue groups other than the opaque suggestion that they remain potentially troublesome. The non-police state corps participants question whether this is in fact a euphemism for political embarrassment, given the same SDS annual report boasts that SDS intelligence had managed to foil 2 publicity stunts from the campaign against police repression, which bore no question of violence occurring, but did contain the potential for embarrassment and media attention through the unfurling of a banner at the royal wedding and a plan to daub a message on the lawns outside the royal apartments. The 1986 SDS annual report concluded speculatively that the run-up to the next general election may lead to, quote, an overspill into the streets, of conflict between the British National Party, National Front and the extreme left. The relevance of the SDS as a unit responsible for providing intelligence on mass public order events was further diminished in 1987 by its own admission due to two factors. First, the reported continuation of the trend away from large-scale demonstrations and towards smaller ad hoc campaign groups. And second, the coming into force of the Public Order Act 1986 in April 1987. Under the Public Order Act 1986, written notice was required for certain types of public processions, with organisers facing the risk of prosecution if notice requirements were not met. The inquiry must query whether a diminishing sense of relevance and utility is what led SDS managers to place the arrests of Andrew Clark and Geoffrey Shepherd front and centre of the 1987 SDS annual report and in the letters of the Home Office. Clark and Shepherd were referred to as being involved in, quote, militant animal rights movement. And whilst the annual report painted these arrests as a success story, there is no real information about the involvement in and contribution to the events and arrests by SDS undercover officers, actions which may well have been criminal. Whilst the 1988 SDS annual report and associated correspondence referred to a resurgence in street demonstrations, the SDS appeared unable to identify any real corresponding increase to the risk of public disorder, thus referring to an increase in the confidence of extreme left-wing groups. Any purported increased threat to public order arising out of left-wing confidence was clearly not made out, as it simply doesn't feature in the 1989 to 1990 SDS annual report. This annual report instead justified the SDS on the grounds that potential for disorder arising out of public protest, quote, is such that it requires continual scrutiny. Rather than being able to point to a threat of public disorder, the report focused on the utility of the SDS in lowering the resources required at events, where the estimates of proposed attendees given by the organisers were wildly optimistic. By the time of the 1990-1991 SDS annual report, the SDS managers were once again scrabbling around seeking to justify the utility of the SDS against the backdrop of the poll tax demonstrations and the Iraq War. In the context of the poll tax protests, it stated that undercovers had been able to, quote, fully identify to investigating officers several persons who were seen to commit criminal acts and who were subsequently arrested and charged. Identifying persons is standard police work that could and should have been carried out by local police forces and by publication in the media. It is not a sufficient justification for the SDS. There's also no evidence that the SDS changed the way in which the poll tax protests were policed. In reference to so-called extremist groups engaged in public order protest against the Iraq War, the SDS is vaguely described as having provided, quote, vital current information concerning the policies and activities of those groups. At this stage, there was no covering letter from the Home Office approving funding, and so the inquiry must ask for an explanation from the Home Office as to what questions they asked and what they were told about the activities and justification for the SDS. 1991 saw a strategic shift in the operation of the SDS, and whilst the operational aims remained the same, as listed and set out on the 20th of May 1969 by Arthur Cunningham, they were accompanied by the articulation of a 5-year strategy to reassess deployments, identify new fields of coverage and optimise coverage within existing resources. By 1992, the focus within the information gathering operational aim had apparently broadened out from militant left-wing extremists to militant political extremists, whilst the operational aim of obtaining evidence relating to breaches of the law had been dropped, referring only to the aim of identifying suspects. It remains unclear from the evidence disclosed so far what reasons were behind the apparent shift in focus, save that the SDS appeared at this time to be grappling with the impact of disclosure requests being made during the course of criminal trials. I'm now going to turn to the adequacy of targeting authorisations by managers. And so for you, this is page 27, paragraph 54 of your hard copy document. In Tranche 2, Phase 1, there is no evidence to suggest that SDS undercover officers were subject to any of the strict controls as required by law for the type of surveillance engaged in by the SDS and in its decision-making. The key themes emerging out of Tranche 2 Phase 1 evidence of the undercover officers are of SDS managers and senior special branch officers directly taking targeting decisions, but undercover officers describing minimal oversight, supervision and feedback by SDS managers, including in relation to welfare. The undercovers were often left to their own devices as to which groups to target, and they were given significant discretion. The undercovers do not describe SDS managers consistently and frequently reviewing the necessity or proportionality of SDS operations and deployments, either before or during the deployment. Although there is evidence to suggest SDS managers knew they should do this. Feedback was sought by SDS managers from customers towards the end of Tranche 2. Notwithstanding the level of direction provided as to the initial targeting decision, it's apparent that managerial oversight as to targeting remained light touch. The initial targeting of the SWP in July 1991 by HN78 Trevor Morris was decided upon by SDS management as he was then, quote, more or less left to get on with it, and developed his targeting as he thought appropriate. HN78 Trevor Morris does not recall any specific targeting with generic tasking communicated by a DCI, DI or DS at the twice weekly meetings, and no real change or refinement in his tasking. HN65 John Kerry was not given any further guidance on the information he was expected to obtain. There is some very limited evidence of managerial oversight and feedback on intelligence reporting, but this appears to be the exception. Minimal intervention took place with respect to the assessment of proportionality and necessity of some deployments once they were underway. For example, HN88 Timothy Spence remained in place having infiltrated the Hackney branch of CND, and he continued to report on CND in 1986, despite managerial knowledge of him, quote, finding things slow and, quote, being slightly underemployed as early as 1984. His own account of his pattern of working life was that, quote, there was more hanging out and socialising than formal meetings. Despite a suggestion from the security service that he be moved to infiltrate the SWP, HN115 DCI Waite made the managerial decision that he should remain in the CND. It also remains to be seen what consideration was given to the implications of infiltrating a so-called associate group of the SDS, his intended target. The lack of concern about reporting on associate groups indicates that the SDS viewed anyone engaged in political activity as fair game, and they were consequently subject to a hoovering up of any personal data. A question for the inquiry, again, is to explore whether safeguards were in place in relation to associated groups. HN19, Malcolm Shearing, describes numerous months going by where he says he may have had nothing to report on, and he postulates that the office may have been tactful and even shredded a report of no significance he submitted to help justify his deployment. He suggests that it would have been obvious from his reports that the RCP BML were a diminishing group and that his deployment wasn't the best use of resources. Despite this, he wasn't moved. HN19 states, I was in a comfortable rut and I didn't motivate this change. Even after Detective Chief Inspector Short accepted in a meeting with the security service that HN19's deployment was no longer justified, it took a further few months for HN19 to be ordered to move his targeting. The inquiry is also asked to scrutinise the evidence of Tranche 2 SDS managers about their role in authorising and reviewing targeting. For example, in Tranche 1, you recall, sir, that HN307 Trevor Butler suggested that HN65 John Kerry's tasking to the CND may have occurred once he had left the SDS and that he had, quote, no dealings with anybody reporting back on the CND. Yet evidence disclosed in Tranche 2 Phase 1 shows that Trevor Butler signed off on HN65's reporting on the CND. And the evidence of HN65 is that the targeting of CND was arrived at, quote, by consensus with his managers. Now, in terms of the justification in respect of public order targeting, the non-police state call participants' written opening summarises the evidence in detail. So I just want to make some short preliminary observations now on the evidence. The resource justification is used in Tranche 2 Phase 1 by undercover officers as a justification for the SDS, often in circumstances where there is no credible public order threat. One example includes HN65, John Kerry, who states, as far as I'm aware, my reporting contributed to effective policing of CND and other events and more efficient deployment and the use of NPS resources for public order, as much by informing assessments to show that there was no real threat of public order. Suggestion that intelligence was sought to assist in effective policing must be viewed in the context of the intelligence reports. There is ample evidence of reporting which appears OTOs given the documented evidence of liaison between the organisers of peaceful events and the police, with examples including CND and HN65 John Kerry. A further example can be found in an intelligence report from October 1983 from HN33 Lee Bonser on the Lambeth Peace Forum, where she stated, quote, although local police have not yet been told of these plans, one of the organisers intends to inform them 2 or 3 days before the event. HN78 Trevor Morris suggested that he provided a detailed report to assist in guiding uniformed officers as to how the Welling demonstration should be policed, and yet he says this was ignored, calling into question the purported public order value of the intelligence gleaned. HM Roger Pierce suggests that the SDS achieved the benefit of, quote, maintaining public tranquility and preventing public disorder, as the intelligence, quote, enabled uniformed branch to formulate a more effective policing plan for demonstrations. However, that justification inevitably requires heavy caveating, as he importantly states that he, quote, cannot give specific examples of this justification in practice in terms of the work of his colleagues because of the secrecy of the operations. HN90 Mark Kerry states that the main objective of his deployment in the SWP from 1988 onwards was to provide useful public order intelligence, suggesting that such intelligence was vital because of the fact that there was no requirement for demonstrators to liaise with the police ahead of marches and pickets. But he doesn't address the impact of the coming into force of notification requirements of the Public Order Act 1986. Some undercover officers provide alternative justifications not seen in T1. For example, HN65 John Kerry refers to the need to avoid political and diplomatic consequences that would follow if non-violent direct action had the significant potential to engage US security personnel present on the airbase at Greenham Common. HN25 Kevin Douglas refers to information that he provided preventing, quote, national embarrassment, and attempts to justify some of his reporting during his deployment led HN90 Mark Kerry to suggest that he was gathering information which may help others recruit people as informants or sources. Some undercovers do not even attempt to justify some of their intelligence gathering and tasking, simply implying that the gathering of limited information was also permissible on the basis that it was, quote, all grist to the mill, or alternatively, as was heard in Tranche 1, that it was the job of others to filter intelligence and determine its relevance. Now, in relation to subversion, in Tranche 1, Counsel for the Inquiry noted that in relation to the justification of the SDS in the context of subversion, that, quote, no one appears to have considered whether, after its introduction, both limbs of the Harris definition were met, and had they done so, there is a strong case for concluding that they should have decided to disband the SDS. So you noted in the Tranche 1 interim report that the Harris definition of subversion required the presence of a threat to the safety and well-being of the state, which is an objective consideration. There was plainly no evidence of subversion in the open material in Tranche 1. In Tranche 2, the Security Service Act 1989 becomes law, but despite there being no reference to the term subversion, the language of the Harris definition is reflected in Section 1.2 of the Act. The Right Honourable Douglas Hurd MP expanded upon his predecessor's comment on subversion when he introduced the Act in Parliament and stated, the Security Service is not interested in the normal and proper conduct of the trade unions of this country. It is not interested in thwarting those who seek to persuade others that government policies are wrong or that their priorities are wrong. It is not interested in those who join together to make their views heard on, for example, the environment or on our defence policies. It is interested in any who might collectively or individually, overtly or clandestinely, be planning the deliberate overthrow of our parliamentary democracy and in doing so, present a real threat to our security and safety. So you've already commented and identified the questionable unofficial approach to the definition of subversion in the confidential side letter that was attached to the 1984 Home Office guidelines on the work of a special branch. It contained the suggestion that a group engaging in lawful activities could be subversive if the long-term aims were subversive. The non-police state corps participants await an explanation from the Home Office, the Security Service and the Metropolitan Police Service as to how the approach to subversion in the closed side letter was thought to be justified in Tranche 2 and how it satisfied the requirement for an objective and, quote, real threat to our security and safety. In the opening statement for Tranche 2 Phase 1, the Metropolitan Police Service accepted that in respect of groups who were considered by the Security Service to be subversive, quote, it is acknowledged that except in specific instances where individuals in those groups were involved in serious crime or disorder or presented an active threat to national security, as opposed to simply holding subversive views, their long-term infiltration by UCOs on a just-in-case basis was a disproportionate method to gather intelligence on them. In terms of the justification in respect of subversion, the following propositions derive from the Tranche 2 Phase 1 disclosure. The Security Service exercised influence on SDS tasking and targeting throughout Tranche 2, making questionable demands and requests going beyond the official and unofficial definition of subversion, including after 1989, with the majority of SDS product including vast amounts of sensitive personal data being sent to Box 500. This indicates that despite the shift in its priorities, the Security Service remained the main customer for the SDS in Tranche 2. The disclosure also shows that SDS managers do not appear to, quote, exercise strict control over the selection of targets, particularly where the activities were, quote, legitimate and peaceful, and there is no evidence that targeting was, quote, conducted with particular care in areas such as educational establishments, trade unions, and racial minorities. And of course, this was required in the 1984 guidelines. Many undercovers admit that they were left to their own devices insofar as targeting was concerned and were given significant discretion. Undercovers had a confused and inaccurate understanding of subversion, which operated as a catch-all approach, and there is a suggestion that the Home Office even designated a group as subversive. As in Tranche 1, undercovers did not appear to question or have the definition of subversion clarified by managers. There is evidence that SDS managers themselves did not understand what constituted subversion. There is evidence that SDS reporting was being used by the Security Service to determine whether a group was subversive, as opposed to already meeting the threshold. And the SDS also retained a cosy relationship with the Security Service, with continuing trips to the pub, and as noted by Mr. Menon KC earlier, during the Tranche 2 period, Roger Pierce had meetings with a Security Service desk officer, which were facilitated by SDS management, but described as being against official policy. In the unredacted Tranche 2 Phase 1 disclosure, there is no evidence of subversion as understood by Parliament, and many undercover officers accept that they did not witness actual subversive activity. I now want to make some comments on the SDS annual reports and how they deal with subversion. So this is your page 35. The SDS annual reports for Tranche 2 do not directly address the definition of subversion, and the 1983 annual report didn't even mention subversion. Between 1984 to 1986, the SDS annual reports assert that it was the SDS's duty to supply information to the Special Branch and Security Service concerning individuals and organisations considered to be subversive, referring to the invaluable contribution made by the Security Service in monitoring subversive elements. By 1991, there appears to be the beginnings of an official recognition in the annual reports that the landscape may be changing in terms of the Security Service interests and demands on the SDS. By 1992 to 93, the, quote, long-heralded changes in the study of subversion by the SDS had led to a reduction in the number of reports that were being sent to Box 500, quote, because of the new criteria. In 1992, Special Branch lost primacy on investigating Irish Republican terrorism on the mainland to the Security Service, and HN90 Mark Kerry suggests that this led to a redirected attention and some resources away from counter-subversion. He claims that this change also reflected a new assessment of the threat from subversion in the United Kingdom due to the fall of communism throughout Eastern Europe and the former Soviet Union. The inquiry must question whether the shift in the regulation of the security service impacted on the SDS and whether there's any link to the emergence of the new self-identified area of work for the SDS in the 1993-1994 SDS annual report to the, quote, irritant and often unlawful activity of groups which included, quote, environmental, ecological activism. Whatever the official position, SDS position, in Tranche 2, the Security Service were clearly interested in environmental activists. For example, in 1991, the Security Service asked HN86 if HN5 John Dines could give them an update on the anarchist London Greenpeace from a monitoring point of view. The SDS noted to F4 of the Security Service that there were only 4 hardcore members, that the group had been infiltrated by McDonald's, and that the latter was taking out injunctions against LGP for libelous literature. HN86 that said that he would ask HN5 to produce an update on the group. Now, in terms of influence of the Security Service on SDS targeting, whilst the 1983 SDS annual report referred to the final decision on targeting resting with the officer in charge of the unit, it acknowledged that to avoid duplication of effort by other sources, the initial placing of each officer is arrived at by reference to squad chief superintendents and the Security Service to ensure greater customer satisfaction. A prime example of the Security Service influence on targeting in the earlier part of Tranche 2 is the continuing targeting of the CND throughout 1981 to 1986 by HN65 John Kerry and HN88 Timothy Spence. HN65 John Kerry's reporting on the CND's spectacular growth in membership in 1982 was praised by the Security Service in a letter to the Deputy Assistant Commissioner Special Branch on the 22nd of February 1982, expressing thanks for the useful report on the, quote, relative influence of the various subversive groups within CND, which accords very well with our own thinking. Specific requests were made by the Security Service for information relating to non-violent direct action training workshops, and these were provided. Despite the Security Service language relating to subversive groups within CND, HN65 John Kerry accepts that his experience of CND at all levels and the vast majority of its membership only supported peaceful activities. Whilst the view of the SDS was made clear in March 1984 that, quote, there was no effective ring of subversives unduly influencing the democratic structure of the CND, but reporting continued on what appears to be the result of the Security Services having, quote, put their case face by face on the matter. Despite the Security Services putting their case, in 1984, the absence of a credible subversive threat was acknowledged even by tasking undercovers with keeping an eye open for any major change. Justification was therefore based on a projection of subversion rather than the reality of it. That this was unjustified was plainly known by Special Branch and the Security Service, hence an apparent discussion about reviewing the infiltration of CND following the Parliamentary Select Committee in January 1985. By October 1986, the SDS was still offering the Security Service the opportunity to request the infiltration of CND, asking whether the Security Service wished to support a successor, by which point the Security Service was adamant that there was no such requirement. However, evidence shows that the SDS continued reporting on the CND, and those intelligence reports were provided to the Security Service via Box 500 even as late as November 1986. Whilst the contemporaneous documents show reference to deployments being made or information being provided at the request of Security Services in order to report on subversive elements, HN88 Timothy Spence denies his work was in pursuit of intelligence gathering on subversives threats at all, stating, I would not consider these groups to be subversive in any common use of the word. Their aims were to improve particular aspects of society from their point of view, rather than overthrow the current workings of the state. Undercovers also participated in an approach of hoovering up and filtered intelligence unrelated to the group in which they had been deployed, sometimes plainly at the direction of senior officers. For example, HN65 John Kerry received an instruction from a manager in S Squad who commented, "While you're gliding down the river, don't forget to glance at the banks," which was taken to mean that information, quote, however peripheral or even wholly unrelated, should be delivered to office staff to allow them to determine the importance. Now, just turning to prevention and detection of crime, non-police state corps participants will deal with this topic in Tranche 2, Phase 2, so I'll just make some brief points. It's important to assess whether the SDS prevented or detected any crime in respect of the Tranche 2, Phase 1 undercover officers. On this issue, the SDS annual reports cannot be relied on as accurate and impartial contemporaneous documents, given the tendency towards exaggeration seen in Tranche 1. The non-police state corps participants have yet to see any special branch threat assessments or feedback from the customers of SDS reporting. The non-police state corps participants note that in the 1992-3 SDS annual report, on their own admission, SDS managers conceded that they had little insight into how to measure the accuracy and relevancy of their work, noting that, quote, the SDS is unique within the British Police Service. Nevertheless, from the extremely small sample size of the survey that went to Special Branch, 222 surveys and 133 replies, only 39% said the SDS reporting was useful, 60% said it was of interest, and a mere 27.81% thought it was accurate. From the security service, when they were sent customer feedback, there were 39 replies from a 10% sample. The responses indicate that only one customer out of the 39 replies considered that the SDS product was extremely valuable. At the cusp of T2 to Tranche 2 to Tranche 3 in 1992, the SDS had produced 1,425 reports, with only 611 apparently relating to events affecting public order. Even on their own evidence, the SDS remained preoccupied by producing totally unjustifiable reporting for the security service, much of which was inaccurate and had no value. And I want to turn to make some comments about operational governance and oversight. So this is now page 41 of your hard document. Dealing first with the government and the Home Office. So you found in the interim report that the Home Office took little, if any, interest in the activities of the SDS and received little information about them between 1977 and 1982. As of 1984, the Home Office was requesting to have more information about the groups and activities at the focus of the SDS's work via discussions with the Special Branch. The request for discussions acknowledged the inevitable political sensitivity of this sort of operation. The timing of this request is potentially significant, coming after the publication of the Police Accountability Report in January 1983, which put the Home Office on notice that SDS targeting had, quote, gone too far in targeting normal and legitimate political activity. Following a suggestion from Michael Partridge, Deputy Under Secretary for Police Affairs, to Assistant Commissioner Crime John Dello, that it would be helpful to know which groups were the focus of the SDS, a visit took place on the 5th of June 1984 by Roy Harrington F4 Division of the Home Office to Commander Peter Phelan. This occurred at the instigation of Sir Brian Cubban, who was, quote, concerned to know that the SDS could be defended as a current response to current problems and was not just something which had been allowed to drift on after having been set up for a specific purpose in 1968. Having been shown the 1983 SDS annual report by Peter Phelan, Roy Harrington expressed the view that he had enough material to, quote, allay Sir Brian Cubban's fears. And he later confirmed in a letter dated 16th of July 1984 that both Michael Partridge and Sir Brian Cubban were content with the squad's role, including how it had been adapted. This level of interrogation led to a proposal by Deputy Assistant Commissioner Colin Hewitt to provide more information on groups targeted in the annual grant request letters to the Home Office. A further discussion with Peter Phelan appears to have been proposed for 1985, and in 1986, during John Gilcott's early weeks, Commanding Officer Simon Crawshaw took the SDS annual report to him and discussed the contents. Now, it is of real significance that the 1987 SDS annual report was seen by the then Home Secretary Douglas Hurd, who, quote, expressed his approval at the work referred to in a letter from Deputy Under-Secretary of State sent in 1988. It appears that the work being referred to was the infiltration of groups leading to the arrest of Andrew Clark and Geoffrey Shepherd. This letter has not been disclosed by the inquiry, so it is not yet known whether the Home Secretary saw the 1987 SDS annual report before or after he addressed Parliament on the Security Service Bill in December 1988. Governance arrangements do not appear to have been made by the Home Office in respect to the SDS because of any of these discussions, suggesting that the effective practice seen in Tranche 1 of the Home Office rubber stamping the SDS continued into Tranche 2. By Tranche 2, the structural permanency of the SDS appears to have become accepted in the mind of the Home Office, as in 1989, the need for formal ongoing annual review and funding correspondence on the groups being targeted by the SDS ceased. The question of the authorisation of the SDS was then transferred to the NPS and ultimately to the Special Branch. This decision was taken by the Deputy Under-Secretary of State in 1989 and was made with the proviso that any, quote, significant change to the squad's role, targeting and operational practice would, quote, require further consultation, thus leaving the SDS with even more autonomy compared to Tranche 1. Now, the Metropolitan Police Service at the highest level was preoccupied with embarrassment. The Home Office was on notice that SDS undercover officers were being used to prevent embarrassment to the state where there was no public order threat. The campaign against police repression is described within the 1986 annual report as espousing non-violence in support of its aim, which was opposing the Public Order Bill, but that it had the potential for causing severe embarrassment for the state. And in a letter of 2nd of February 1986 to Michael Partridge, from John Dello, seeking authorisation for funding for the SDS for a further 12 months, there is again that reference to foiling of 2 publicity stunts surrounding the royal wedding, which I've already mentioned. Whilst the SDS annual report of 1989 sets out information about the approach to targeting, there is no evidence that this or any subsequent reports were reviewed by the Home Office, including actual intelligence reporting. A later SDS annual report for 1990-1991 acknowledges the political sensitivity of the SDS operation and refers to that as a reason for taking great care to ensure the targeting and penetration of an organisation can be fully justified on the basis of the Commissioner's responsibility for preservation of public order in the metropolis. There is no evidence in Tranche 2, Phase 1, to suggest that this purported renewed energy to take great care on targeting decisions arose from any feedback or oversight from the Home Office, despite earlier concerns around the police accountability report. Throughout the Tranche 2 period, the Home Secretary remains accountable for the actions of Special Branch and Security Service, and this was indicated by the Secretary of State for the Home Department, Kenneth Clarke, in 1992. The evidence given by HN 307 Trevor Butler in Tranche 1, Phase 3 was that once a month he met with an individual from the Home Office who had a role in enabling SDS operations. Evidence should be sought on whether this practice continued beyond HN 307 Trevor Butler's time, which concluded in around January 1982. The details of any individuals involved and any associated material should be obtained and disclosed. The January 2015 investigation into links between the SDS and the Home Office, which, as we know, is called the Taylor Report, concluded that when funding ceased in 1989, no accountability was required until the SDS closed in 2008, and no significant evidence was identified of any links to the Home Office throughout this period. The Taylor report noted that detailed file searches failed to identify relevant documents, and despite the availability of a consistent file reference, there's no record to show where the file is or when it may have been destroyed. The report notes that this is a concern, quote, given that the material would have been classified as secret or top secret, it is not possible to conclude whether this is human error or deliberate concealment. It is inconceivable that there was not continued information sharing and liaison between the SDS and the Home Office throughout the Tranche 2 period. HN 78, Trevor Morris states that the Home Secretary himself, along with the Commissioner, wished to visit an SDS safe house to thank undercover officers for the intelligence provided relating to the Welling demonstration on 16th of October 1993. The inquiry should obtain a fuller picture of the state of knowledge of the Home Office during this period, including an explanation for the apparent strategic change which took place from around 1990. Now, in terms of wider government knowledge beyond the Home Office, evidence disclosed in Tranche 2 Phase 1 indicates that the SDS had customers at the highest levels within government, including the then Prime Minister, Mrs. Margaret Thatcher. HN 33 Lee Bonser states, in respect of a conversation she had with the superintendent prior to joining the SDS, quote, at our meeting, he indicated that the Prime Minister wanted to know what the Greenham women were doing, and so he, the superintendent, was asking whether I would be interested in helping the police find out. Given the extent to which the then Prime Minister and her ministers were concerned about the embarrassment being caused to the UK government by the women of Greenham Common, this was an opportunity for the SDS to please those at the very top of government, reminiscent of Chief Inspector Conrad Dixon's original offer to do something about groups which were embarrassing the government of the day in 1968, and to attempt to justify itself on a more national scale. The state, in turn, benefited by being able to utilise a secret unit which would pass under the public's radar, in this instance to undermine the movement at Greenham Common, in effect acting in a fundamentally undemocratic way so as to interfere with popular opposition to what was an unpopular government policy. Now, turning to Metropolitan Police Service operational governance and oversight. The SDS closing report concludes that the SDS directed operations with, quote, significant tactical latitude with a minimal organisational constraints, end of quotes. This is likely because of the special treatment afforded to the unit. Quote, there is no doubt that the SDS operation was perceived as the jewel in the special branch crown, and the level of support afforded by the top echelons of the SPS was reflected in the number of visits made to their off-site premises by its senior officers. End of quotes. HN 85 Roger Pierce states, the Whitehall security infrastructure held the SDS in high regard because of its operational effectiveness. In Tranche 2, there were more regular visits by undercover officers by senior Metropolitan Police Service officers. By January 1984, it was well known to the Deputy Assistant Commissioner that deployments were envisaged to be a 4-year period, so he issued instructions to be provided with proposed deployment dates. SDS annual reports refer to visits to the Safe House flat in 1986 and 1987 from the Assistant Commissioner J.A. Dello, involving, quote, an exchange of views described as friendly and constructive on both occasions. AC Dello, as well as Deputy AC Crawshaw, were fully appraised of all aspects of the SDS operation and clearly failed to ask probing questions or institute any proper process for scrutiny from within the Metropolitan Police Service. Friendly discussion was clearly no substitute for formalised oversight arrangements. The picture that begins to emerge very clearly in Tranche 2 Phase 1 is of managers being aware, condoning and even promoting some of the most abhorrent tradecraft, with such practices becoming further cemented as tradecraft in later tranches. For example, HN 67 Alan Bond, who was alleged to have fathered a child through a sexual relationship with an activist, whilst deployed, returned to the SDS as a detective inspector and second in command between 1991 and 1993. HN 10 Bob Lambert, allegedly responsible for a wide range of abhorrent behaviour during his time, became a detective inspector managing the SDS from 1993 into the Tranche 3 period. Lambert was also heavily involved in the nascent mentoring scheme. HN85, Roger Pierce, became Commander Operations with oversight of the SDS in October 1996, followed by a concurrent role as Director of Intelligence for SO10 and SO11 in October 1998. Various officers, including HN67 Alan Bond, took up roles as mentors to incoming SDS officers and are recorded as having provided extended counselling at times of added stress related to activities of former field officers. The inquiry must investigate whether a handful of the worst offending undercover officers played a significant part in abhorrent tradecraft continuing through the later tranches. Category H demonstrated in their Tranche 1 closing statement the extent to which Metropolitan Police Service officers, including commissioners, viewed legal constraints upon police action as an impediment to policing, which they were required to evade. The non-police state corps participants question whether a similar sense of arrogance and superiority within SDS management continued into Tranche 2. As the SDS 2009 closing report details, quote, officers were not required to attend the National Undercover Training and Assessment course by their management after its introduction, as it was not seen by the SDS management as appropriate for what was considered a unique operation. Now, the topics of selection, training, management and care of undercover officers, recruitment and vetting are all dealt with in the non-police state corps participants' written opening. And clearly, given the pressures of time, I'm not going to be talking about those matters today. But I will, if I may, say a few comments about targeting. And this is page 60, sir, of your written document. So in Tranche 1, the SDS developed a tradecraft to monitor family justice and defence campaigns, including those with some element of anti-racism campaigning and those focused on police racism, harassment and police brutality. On the cusp of Tranche 2, the SDS also became interested in reporting on the activities of police monitoring groups and police accountability groups. In Tranche 2, SDS reporting on defence and family justice campaigns, police accountability and monitoring groups and anti-racist groups exploded. Former undercover officer Peter Francis has stated that his tasking was to find out, quote, any intelligence that might be used by the NPS to smear the Lawrence family. Now, the evidence in Tranche 1 and Tranche 2 Phase 1, and in particular the actions and reporting of HN12 Mike Hartley, HN88 Timothy Spence, and HN25 Kevin Douglas, illustrate the extent to which Category G, so that's the family of Stephen Lawrence, Dwayne Brooks OBE and Michael Mansfield KC, fall squarely into the sightlines and established SDS tradecraft as matters stood at the end of the Tranche 2 period. The Home Office and senior members of the Metropolitan Police Service were aware that the SDS was reporting on justice and defence campaigns as well as on police-related pressure groups and tacitly or explicitly approved this. Apart from the clear and consistent references to police accountability groups and defence and justice campaigns in the annual reports, there is a letter from J.A. Chilcott of the Home Office, dated the 16th of June 1987, thanking Deputy Assistant Commissioner HN 603 Simon Crawshaw of the Metropolitan Police Service for bringing the latest 1986 SDS annual report over and discussing it with Chilcott during his early weeks, stating that, quote, we are content with the report of these activities over the past year and the way in which it is planned they should be conducted in the future. Now, this annual report sets out the direct penetration or close monitoring of, amongst others, the Guildford 4 campaign. This was the year of Lord Peter Imbert's appointment as Commissioner of the Metropolitan Police Service. The significance of this will not be lost on the inquiry. Lord Peter Imbert, as Deputy Head of the Metropolitan Police Anti-Terrorist Branch in 1974, was the police officer who oversaw the arrest and interrogation of the Guildford 4, an investigation that was later characterised by Lord Chief Justice Lane as, quote, a sequence of false confessions and police deceits. The extent of the SDS tradecraft of targeting and reporting on a full range of campaign groups in Tranche 2 can be placed in stark technicolor by reflecting on some of the various campaign groups with special branch registry files which feature in SDS reporting in T2P1. And I'm just going to read out a non-exhaustive list of some of those groups. So under the heading Family Justice Campaigns, we have the Friends of Blair Peach, the Gross Family Support and Community Defence Campaign, Joy Gardner Memorial Campaign, the Roach Family Support Committee, the Trevor Monaville Campaign. Under the heading Community Campaigns, we have the Hackney Community Defence Association, the Hackney Legal Defence Committee, the Hackney Solidarity Campaign, Lambeth Police Consultative Committee, Southall Black Sisters, Newen Monitoring Project, the Stoke Newington and Hackney Community Defence Campaign. Under defence campaigns, we have the Broadwater Farm Defence Campaign, the Tottenham 3, the Free Birmingham 6 Campaign, the Guildford 4 Campaign, the Newham 7 Defence Campaign, the Newham 8 Defence Campaign, and the Danny McNee Support Group. Under anti-racism groups, we have the Anti-Racist Alliance, the East London Workers Against Racism, the East London Campaign Against Racist Attacks and Police Harassment, Workers Against Racism, and the Anti-Nazi League. Under police accountability and monitoring groups, we have the GLC Police Committee Support Unit. Under community centres, the Colin Roach Centre and the Newham Civil Rights Centre. And under NGOs, we have Inquest, the Institute of Race Relations, and the National Council for Civil Liberties, obviously now known as Liberty. Moving on to the targeting of members of Parliament and elected politicians. In Tranche 2, Phase 1, as we've seen in Tranche 1, senior MPS and SDS managers gave no consideration to the threat to democracy and the political and democratic process of the mass gathering of intelligence on elected politicians, elected representatives, political organisations, and those involved in lawful political activity. During Tranche 2, the SDS directly penetrated or closely monitored Labour Briefing, a magazine produced by members of the Labour Party, whose contributors included Tony Benn MP and Jeremy Corbyn MP. The Labour Committee on Ireland, a pressure group within the left wing of the Labour Party, which sought British withdrawal from Northern Ireland, was also directly penetrated or closely monitored from April 1989 to the end of March 1990, and during the year from April 1990. The non-police state corps participants' written opening contains much further detail on how elected politicians feature in the Tranche 2 Phase 1 material. Moving on to trade unions. Reporting on trade unions occurred in Tranche 2, and the disclosure shows that it clearly went further than simply monitoring industrial disputes or public order, but was part of the broader ideological and anti-democratic attack on the entire left, which treated trade union membership synonymously with subversion. In this sense, the reporting on the Labour Party, elected politicians and trade unions are all facets of the same problem within the special branch in Tranche 1 and Tranche 2 and should be seen in this broader light. The non-police state corps participants' written opening contains much further detail on how trade unions and their support groups were targeted and reported on in Tranche 2, but I do just want to mention now very briefly the extensive targeting in Tranche 2 Phase 1 material of miners' support groups supporting striking miners as a particularly stark example of unjustified political policing. The 1984 annual report notes that miners' support groups were effectively penetrated by SDS officers. Some examples include HN12 Mike Hartley going with the SWP to South Wales in March 1985, reporting on a group who were providing the Strike Support Committee and local miners with cash and food, even reporting on food distribution. HN33 Lee Bonza reported on speeches given by miners' wives, and HN67 Alan Bond reported on when a coach carrying food for miners and their families would leave Croydon. Now turning to spying on lawyers, which has been dealt with briefly by Mr. Menon KC already today, there is clear overlap between monitoring and direct targeting justice and defence campaigns and lawyers in Tranche 2. The evidence before this inquiry overwhelmingly demonstrates that to maximise intelligence gathering at all costs and justify police action and gain a litigation advantage, SDS managers oversaw the development of a practice of intrusive SDS reporting on lawyers and material subject to litigation privilege, with no sense that such monitoring or targeting would be legal, properly justified, or in any way proportionate. This was evidently enabled by a culture of disregard for legal or ethical norms and an utter lack of appreciation for the rule of law, unacceptable in a democratic society. This also demonstrates the total disregard which both the SDS and the Special Branch had for the rights of individuals to obtain advice and legal representation. The non-police state court participants' written opening statement also deals with what the Tranche 2 Phase 1 material reveals on STS targeting and race, the far right, blacklisting and vetting, conscious and subconscious sexism and misogyny, abhorrent reporting, STS undercover officers committing criminal offences and acting as agent provocateur. Now, so I'm just looking at the time. I've got a few comments to make on procedural issues, which hopefully I will get done by 1:30 when I know the stenographer needs to break. So, sir,
you're doing very well. Forgive me for interrupting. You're doing very well indeed, and I know that she is perfectly content for you to continue until you finish.
Thank you very much.
You are doing expeditiously. Thank you.
So, so for your benefit, I'm now moving back to the beginning of the written document that you have. So that's going to be page 4 of your document. When on the 29th of June 2023, the then Home Secretary Suella Braverman laid the interim report before Parliament, she noted that this first report has taken 8 years to compile at a cost of 64 million, a significant amount of which has been spent on legal costs. I know that those affected by the issues under examination will wish this inquiry to come to conclusion swiftly, so as to bring accountability and closure. The government are engaged with the inquiry chair and continue to stress the importance of delivering as soon as practicable. At a meeting with the members of the inquiry legal team on the 27th of September 2023, the inquiry unexpectedly announced that it would produce its final report by November of 2026. The inquiry website now confirms that the final report is to be published by December 2026. This inquiry has clearly been placed under intolerable pressure by the Home Office to come to its final conclusions sooner than originally envisaged. The non-police state court participants can only assume that the rationale behind this decision by the Home Office is to save costs. However, it's also become clear in the lead up to the Tranche 2 evidential hearings that the imposition of this arbitrary end date by the Home Office has led to the inquiry managing disclosure in a manner that has resulted in huge personal and emotional burden being placed on the non-police state court participants, whilst profoundly impacting on the ability of many of them to effectively participate in Tranche 2 Phase 1. In short, some non-police state court participants have been unable to prepare their witness statements as they were not provided with all the relevant disclosure in a timely manner, and some have provided statements while disclosure remains outstanding. The problems surrounding late disclosure must be seen against a backdrop of repeated promises of disclosure to some non-police state court participants, which have simply not been met by the inquiry, and some non-police state court participants were denied access to the Tranche 2 Phase 1 open hearing bundle until they had submitted their witness statements. Many non-police state court participants have been asked to provide witness statements after receiving limited and redacted disclosure that the inquiry considers, quote, relevant and necessary. Only a small number of court participants have been given disclosure of unredacted statements from former undercover officers. Many non-police state court participants have been disclosed only a fraction of the statements and are prohibited from speaking to each other about the material, thus frustrating their ability to understand and comment on the wider context. It is difficult for the non-police state court participants to understand the justification for withholding access to the hearing bundle and generally limiting disclosure to the non-police state court participants where such disclosure has either been served on and or already seen by many of the other state court participants in what is an inquisitorial process. This is particularly so, given this inquiry has been established so that those who've been subjected to historical policing injustices, abuses, and miscarriages of justice can understand the truth about how the state violated their fundamental rights. The non-police state court participants consider that in adopting this approach, the inquiry has lost a valuable opportunity to obtain their perspective on the totality of the material. It will be difficult to rectify this during the limited time available in the evidential hearings, and in circumstances where certain individuals with the knowledge to assist the inquiry will not even be giving evidence. The non-police state court participants remind the inquiry that they have valuable evidence to give on the wider context and the linkages between deployments and SDS tradecraft, which may not be immediately apparent to the inquiry when determining the relevance of documents for each non-police state corps participant. Now, the non-police state corps participants in Tranche 3 have observed the mounting procedural crisis in Tranche 2 and are deeply concerned about the implications this has for future tranches, which will be investigating more recent police practices going into the 21st century and where the quantity of available evidence is likely to increase. It appears from recent correspondence with the inquiry that the intense pressure from the government to conclude this inquiry by 2026 may lead to the exclusion of crucial evidence in Tranche 3. The non-police state corps participants note that they have provided the inquiry with information about spying on groups in Tranche 3, but those groups are not currently listed on the UCPI website. Now, the inquiry has responded as follows, quote, "Some RLRs have raised queries in respect of groups and campaigns which do not have CP status. For the avoidance of doubt, separate disclosure will not be given in respect of these groups' campaigns. The inquiry is working to a very tight timetable and extensions of time will not be given." Now, this means that many of the most important groups from the Tranche 3 era will not receive disclosure, and group statements which have been offered to the inquiry will not be sought. Some disclosure pertaining to these groups may be received by individual non-police state corps participants because they happen to be named within the documents, but that will not provide a complete picture of the extent of the spying, particularly as the inquiry has stated, quote, "We do not expect costs to be incurred by a lengthy review of documents. Evidence should be concise and focus on the questions asked." So the non-police state corps participants remind the inquiry that it is a clear requirement of its terms of reference to investigate whether and to what purpose, extent and effect undercover police operations have targeted political and social justice campaigners. That cannot be done without hearing proper evidence from individuals associated with groups that were spied on by multiple undercover officers from both the SDS and the National Public Order Intelligence Unit, often for years and often over a long period of time. At present, who gives that evidence and the questions to be asked about it will be established, quote, "on the basis of the material the inquiry legal team has reviewed to date." So in other words, that means the evidence provided by the police. This approach in effect sidelines the corps participants and civilian witnesses in this inquiry, allowing the perpetrators of the abuse, the police, to frame what evidence is to be gathered. The non-police state corps participants consider this is a completely unacceptable approach, and they urge the inquiry to reconsider its position and to engage with the concerns of non-police state corps participants from Tranche 2 and Tranche 4. The non-police state corps participants wish to make clear that whilst it's important for this inquiry to progress its work without unnecessarily delay, this should not come at the expense of accountability. The non-police state corps participants asked the inquiry to formally recognise the disadvantage faced by all of them in this inquiry. The inquiry is asked to further reflect on and clarify how, moving forward, it will ensure that there is fair and equal treatment of all corps participants in this inquiry. Now, the non-police state corps participants have also been made aware that certain significant undercover officers are outside the jurisdiction and are refusing to cooperate with the inquiry by returning to give evidence. This includes, for example, HN88 and HN33, who have provided statements but are refusing to return to the United Kingdom to give evidence, and they are, of course, very important undercover officers. There is also HN95 Stephen Scutt, HN11 Mike Chitty, and HN5 John Dines. There may be other undercover officers, but these are the ones we know about, including for Tranche 2, Phase 2. The non-police state corps participants who have expressed a view consider that it's disgraceful that these former officers who have retired on pensions funded by taxpayers are able to avoid accountability for their actions. They consider that the inquiry should take all steps to ensure oral evidence can be obtained from former undercover officers who no doubt will return to the United Kingdom in key holiday periods. So the non-police state corps participants ask that the inquiry considers, again, using its powers under Section 21 of the Inquiries Act 2005, backed up with appropriate enforcement. This will send a strong message to all future undercover officers who are considering deliberately evading giving evidence to this inquiry. The non-police state court participants understand that in Tranche 2 there are 15 undercover officers whose evidence will be considered in closed proceedings, and that the inquiry intends to provide extracts of the statements of these undercover officers. As the inquiry knows, the non-police state court participants are concerned that in the first set of closed hearings which took place in Tranche 1, which are termed Tranche 1 Phase 4, the non-police state court participants were unable to play any meaningful role. Despite requests both in previous hearings, submissions and correspondence, the inquiry has indicated that no formal protocol for closed hearings will be published. In Tranche 1 Phase 4, there was no opportunity afforded to the non-police state court participant groupings to ask the inquiry to pursue legitimate further questions arising from the evidence given in the closed sessions. The non-police state court participants are extremely concerned that this inquiry will increasingly rely on closed proceedings. Such a development would be unprecedented in a public inquiry such as this, and it would fundamentally limit the ability of non-police state court participants and the public to participate and learn the truth about why they were spied on by the SDS. With the passage of time, the non-police state court participants once again query whether closed hearings and sessions are necessary, and if they are, they should be an absolute last resort in this inquiry. So in conclusion, the non-police state court participants wish to remind the inquiry that they are not in an equal position to state court participants who are either the originators or asset holders of the disclosure. The non-police state court participants consider that the inquiry has failed to give sufficient consideration to the impact upon them of the chaotic nature of the disclosure and the resultant stress in circumstances where they and civilian witnesses are having to balance the emotional consequences of what they are reading, discovering for the first time what happened to them, whilst juggling their own lives, family, and employment needs. This approach to disclosure by the inquiry further exacerbates the other structural disadvantages the non-police state court participants face. The state court participants have had decades to consider the material before this inquiry, and the undercover officers and managers have an inherent knowledge and understanding of their and their fellow officers' spying. Their legal representatives are also at an advantage. For example, the designated lawyer officer court participant group represents 102 SDS undercover officers, and so can receive and reflect at an early stage on all the intelligence reporting of relevance in a tranche, and well before preparing their opening statement. The non-police state court participants are being given at most months, but often just weeks and in some cases days to consider the material. The inquiry has yet to recognise this inherent bias. In every case, it is the non-police state court participants who are the last to know what has happened, whilst they are given the least amount of time to process a huge amount of material that is deeply personal and upsetting to them. So at the end of Tranche 1, the non-police state court participants remind the inquiry of their core demands and ask the inquiry to take stock. The non-police state court participants are once again asking the inquiry to rethink its procedures and practices to ensure that there is robust public scrutiny of undercover policing in Tranche 2 and beyond, and to ensure that the non-police state court participants are treated fairly and remain at the heart of the process. So, sir, unless I can assist you further, those are my opening submissions on behalf of the non-police, non-state court participants. Thank you.
Thank you very much. May I say two things, one on my own behalf and one at the request of the Metropolitan Police Commissioner's lawyers. On my own behalf, I acknowledge that there have been great burdens placed on non-state court participants who have attempted, frequently successfully, to participate in the workings of the inquiry. I acknowledge the difficulties they face. No system dealing with the vast quantity of material that my inquiry has to deal with can ever be perfect and can never satisfy everybody. I ask those that you represent and all non-state core participants to bear with us while I, with the assistance of the inquiry team, am attempting to get to the truth about what happened. I'm determined to do it. Processes that have been put in place are those that seemed to me and to the inquiry team to be the most likely to enable me to do that. Given that it's a human activity, the end result can never be perfect, and the means by which it's arrived at can never be perfect. All I can ask is for patience. Please bear with me. I acknowledge the worth of the input of non-state core participants. I ask them for patience in allowing me to put it to good effect. I'm sorry about that rather lengthy statement by me, but I thought in the light of what you said, I should say it. The query that I have from the Metropolitan Police Commissioner's legal team can, I think, be more shortly answered. It's pointed out, I think correctly, that you submitted that it was asserted on behalf of the Commissioner that the annual reports were, open quote, simply a stocktake and not an opportunity to persuade senior managers that the unit should stay in existence, close quote. I'm told, and I think this is correct, that that assertion was made on behalf of the designated lawyers team and not on behalf of the Commissioner. If that's right, then I think it should be put right as a matter of correction.
Yes, so I'm sure you're correct in that regard, and thank you for that correction. I think it was probably added at last minute. So if it was incorrect, I apologise.
Thank you very much.
Thank you.
None of us can get everything right all the time. Thank you.
Thank you.
That concludes the opening statements and the proceedings for today. We will resume on Monday at 10 o'clock when we will hear the first live evidence.